thank you for coming in today for your author interview. First question, what are the most common types of dispute in an M&A context?
Well, it's hard to generalise a question like that, but what we sought to do in the book is to reflect the principal types of dispute that arise in an M&A context. So in a pure mergers and acquisitions, so purchase under a sale and purchase agreement, probably the most common types of dispute will be completion accounts or disputes arising from breach of warranty or breach of indemnity. However, we see a lot of disputes, and there's a chapter that deals with that, for example, arising from joint venture agreements and shareholders agreements. And so it's hard to say there's a particular type of dispute, but what we sought to address is in each context, which types of disputes are the most likely to occur.
What reasons are there for choosing arbitration over litigation in resolving these kinds of disputes?
The reasons for choosing arbitration over litigation depend on the circumstances. So in some jurisdictions, for example, Turkey, and that again emerges from the book, people have traditionally chosen arbitration to resolve their M&A disputes because the courts don't have the required expertise to deal with complex commercial arrangements. Now, in England, for example, that's not the case. We have specialised courts with judges who are very well versed in dealing with these types of disputes. So here, if you were under an English law contract in an English law context, the reason for choosing arbitration will be different. So for example, it might be, and this was obviously traditionally, because you want your dispute and your arrangements to remain confidential and to be dealt with in a private setting. Or, this is increasingly the case in a globalised context, because you want an award that you can enforce under the New York Convention in the way that an English court judgment might not be readily enforceable.
Could you tell me what is meant by the terms arbitrability and enforceability?
Arbitrability really seeks to define what types of disputes under a particular judicial or legal system can be made subject to arbitration. So, for example, in some jurisdictions you cannot agree to arbitrate disputes between shareholders, whereas in other jurisdictions that's completely acceptable. So that's arbitrability. Enforceability is how easy it is, and this is what each country by country chapter seeks to deal with, first in terms of arbitrability and then enforceability, is how easy is it to enforce an arbitration award in a particular jurisdiction.
How important is the place of arbitration?
Place of arbitration is crucial. Whenever I'm speaking to clients about how to draft, how to structure your arbitration clause, I always advise that it would be better to concede the governing law, as long as you get a governing law that you're happy deals with the points in a satisfactory way, in return for ensuring that you have your arbitration seat in a place where the arbitration law is modern, where the courts are arbitration friendly and knowledgeable about arbitration, and also in a country that you know the courts will not interfere with arbitration. Clearly, before you even get to those details, you need to make sure that your seat is in a state that's signed the New York Convention so that you can ensure enforceability under the New York Convention elsewhere. But choosing your seat is probably the most important aspect of drafting an arbitration clause.
Are there any key differences between jurisdictions in terms of the enforcement of awards?
Yes, and this is one of the great practical aspects of considering your jurisdiction clause, so whether to go to court and arbitration, and then how you in fact go about planning from the start how ultimately you will enforce. There's no point going through a long arbitration process if at the end of the day you end up with a piece of paper that's not worth anything in terms of actually obtaining enforcement against money or other remedies, for example, delivery of shares. So enforcement should be your starting point. And while most states are now signatory to the New York Convention and state their arbitration friendliness, there is a huge disparity between the way in which different countries treat arbitration awards. Now, there's definitely a trend towards enforcement and less court interference as courts become more familiar with it and states push pro-arbitration agendas. However, the New York Convention contains certain limitations on enforceability. For example, references to public policy, which some courts have used as an opportunity to effectively revisit the entire merits of an award and therefore stand in the way of straightforward enforcement, arguably in contravention of the New York Convention.
What changes are arbitrators and counsel seeing right now, if any?
I think, as I mentioned at the start, the globalization of world business and M&A transactions generally mean that we're seeing more arbitration of M&A disputes, and that was one of the reasons why we felt it was time for a book of this nature to really highlight some of the issues that are occurring. In terms of trends, I think probably the greatest trend I've seen, and this is not directly linked purely to M&A arbitration, is the increase in parties throwing procedural issues to try and slow down and resist enforcement further down the track. So respondents refusing to participate on the basis that that will give them arguably a better chance in their home courts when it comes to enforcement. And an increase in procedural steps such as, for example, challenges to arbitrators and attempts to attack the system throughout the process.
How can companies entering into an M&A deal reduce the likelihood of disputes further down the line?
The best way to reduce disputes is obviously due diligence. Know who you're dealing with, know what you're buying, and none of that will come as any surprise to anyone who's involved in M&A transactions. Looking at it from a more technical disputes angle, I think getting the clause right is crucial. So choosing arbitration if you're contracting with or will need to enforce in a place where court judgments would not be enforceable is a vital first step, because if you have a dispute procedure in your contract which is toothless because the other side knows that even if you obtain a judgment you won't be able to enforce it against them, will immediately increase the likelihood of a dispute having to go ahead. So getting your clause right, choosing the right institution, choosing the right seat, and making sure that you have in place a mechanism which, if successful, would give rise to an enforceable award, puts you in a great position in a negotiation when a dispute arises. And there is a section and a chapter dedicated to the arbitration agreement, and I can't emphasize how important that is. Getting that right avoids everyone's nightmare, apart from litigators, which is litigation about litigation.
What is the best advice you've ever been given as a practitioner in this field?
Keep it simple, and that means keep it simple when you present your claim originally to the other side, keep it simple when you present your claim in the arbitration, and probably most important, keep it simple at the hearing. Choose your best points, don't run your bad points, stop a cross-examination on a high point, don't trawl through questions that you had prepared for the sake of it. If you've made the point, move on. Often you can make more mileage in a cross-examination from stopping early, not allowing the witness an opportunity to make up lost ground. So keep it short, keep it simple. KISS.
Your book, Arbitration of M&A Transactions, is out now. Could you tell us about the key benefits for readers?
I think it's the first time that there's a practical repository of material dealing with this area. So the first section is really a country-by-country guide of issues such as governing law, arbitrability, and enforceability. And governing law is important because in some countries you cannot have M&A transactions regulated by a foreign law. So that's a reason why, for example, shareholder agreements under English law to regulate the operations of companies in Russia and Ukraine are generally routed through a Cypriot company, because you cannot have a foreign law agreement between shareholders in a Russian or Ukrainian company. So what you do is you have a Cypriot parent company, and then you have a shareholder agreement there that's regulated by a different law. And English law is much more flexible in what it allows you to do, and pretty much allows you to agree what you want to agree. And that's one of the reasons, apart from the sort of tax and other reasons, why a lot of Russian and Ukrainian companies are held through BVI entities, for example. Then, as I said, there's a very important chapter on arbitration agreements, which is a crucial way of avoiding litigation about litigation. And then finally, we've got some very, very learned practitioners sharing their experiences, tips, and analysis of the most prevalent types of claims that arise in this context. And so there's some very interesting insights from different jurisdictions about pre-closing disputes, post-closing, completion accounts, and disputes arising from joint venture agreements and the shareholder agreements. And then finally, we have a sort of catch-all section, which really pulls together some of the themes that are true core to arbitration, such as confidentiality. And also one that introduces some of the issues that we're starting to see more and more, so the interconnection between arbitration of private M&A disputes and competition law issues. So I would say this, but I think it's a very valuable addition to the library of any M&A practitioner and anyone involved in this type of disputes, because it provides some really practical tips on how to manage these issues.
Thank you very much.